The Supreme Court just granted, vacated, and remanded a new case that deals with whether or not felons can actually be barred from possessing firearms for their entire life. So let's talk about what just happened. Now, really quick before we jump into this video, I want to thank one of the sponsors of this channel, which is My Patriot Supply. Now, a lot of you guys are aware that there's a ton going on right now in our country. There's a lot going on, and a lot of people have the feeling that we're not headed in the right direction and that maybe some things could be spiraling out of control. If you have that feeling and maybe you're a bit uneasy about what's going on, you're not alone. And a lot of Americans across the board are taking a ton of steps to help themselves be prepared for whatever might come next. And a lot of people are investing in purchasing and getting emergency food supplies. And if that's you and you're interested in getting some emergency food, I would recommend checking out My Patriot Supply. I will have them linked down below in the details section and also in the pinned comment. You can get 3-month emergency kits and other kits, and they're packed with a bunch of different options, a bunch of different food supply options, and a variety of calories. They have like 2,000 calories a day, and then those will last up to 25 years. So again, if you're interested, you can go to preparewitharmscholar.com to get that emergency kit, or you can click the links down below that will be in the detail section and the pinned comment. Now, as I mentioned in the intro, in this video, we're going to be talking about a new order that was issued by the United States Supreme Court, which grants, vacates, and remands another felon in possession case back down to a lower court in light of a decision that they issued recently, which was an 8-1 ruling in the Rahimi case. The case we're going to be talking about in this video is called Pierre versus United States. And in this case, Mr. Pierre asked the United States Supreme Court to review a recent 11th Circuit decision revolving around a felon in possession of a firearm charge and whether or not he forever could be barred from possessing firearms because he has a felony conviction. In this case, he sought for the Supreme Court to review and ultimately reverse the decision down below in light of Bruin and also the recent Rahimi decision. The Supreme Court recently issued a ruling which granted, vacated, and remanded the 11th Circuit decision down below in regards to Mr. Pierre because of the recent Rahimi decision. So they sent it back down to the 11th Circuit for a new decision in light of Rahimi. So we need to talk about what happened in this case and what this means going forward for challenges for individuals who potentially are a felon and potentially want to possess firearms, but they are barred under federal law forever from having firearms because of those felony convictions. Now, you may recall that recently the Supreme Court issued an 8-1 decision in a case called U.S. versus Rahimi. In that case, an individual challenged the constitutionality of the domestic violence restraining order laws, the federal laws, and he challenged them as unconstitutional under the Second Amendment, and he cited there to the Bruin decision. In that case, Mr. Rahimi, between December of 2020 and January 2021, was involved in 5 different shootings in and around the Arlington, Texas area. He was connected with incidents where he shot at a car, and then also another shooting incident where he shot up a Whataburger restaurant because his friend's credit card was denied. So Mr. Rahimi generally was just not a good guy. He had a domestic violence restraining order also issued against him, and the officers there who found that he was in connection with some various shootings then executed a warrant at his home where they found both a rifle and a pistol in violation of that domestic violence restraining order. He was then charged and convicted of possessing a firearm in violation of 18 U.S.C. section 922G8. So again, a federal law which generally prohibits him from possessing firearms because of those protective orders. Mr. Rahimi eventually decided to challenge those convictions and challenge those charges because he claimed that under Bruin, those domestic violence restraining orders, the federal laws, violated the Second Amendment because there was no text, history, and tradition of supporting those federal laws. Eventually, his case made it all the way up to the United States Supreme Court, and in an 8-1 decision, the Supreme Court actually upheld those federal laws, finding that those laws were consistent with the principles and traditions surrounding the Second Amendment. So that was a very interesting decision. It was an 8-1 order, and then also after that 8-1 order in Rahimi, they decided to GVR another case called Range versus Garland. And Range versus Garland dealt with an individual who had a nonviolent felony of lying about food stamps. They also decided to GVR that case back down to the circuit court. But now we have another case which was also just GVR'd by the Supreme Court in light of Rahimi. The Supreme Court just GVR'd this Pierre case back down to the 11th Circuit for a new decision in light of Rahimi. The order of the Supreme Court states that the petition for a writ of cert is granted. The judgment is vacated, and this case is remanded to the United States Court of Appeals for the 11th Circuit for further consideration in light of U.S. versus Rahimi. Now, in this case, the question presented to the Supreme Court that they just GVR'd on was whether a criminal defendant may raise an as-applied Second Amendment challenge to 18 U.S.C. Section 922G1. Now, in this case, in July of 2022, the United States charged the petitioner here, Mr. Pierre, with a single count of violating 18 U.S.C. Section 922G1 for allegedly possessing a firearm when Mr. Pierre had been already convicted of a felony. So he was a felon in possession of a firearm in violation of federal law. Now, in this case, a few months later, Mr. Pierre moved to dismiss those indictments and those charges because he claimed that under Bruin, those federal laws were unconstitutional and must be struck down, and he brought an as-applied challenge to his specific conviction. Now, in a lengthy report and recommendation, a magistrate judge decided to uphold and held that the 11th Circuit pre-Bruin decisions on the constitutionality of 922G1, the Rosier decision, that was actually not abrogated by Bruin, and that Mr. Pierre's possession of a firearm fell within the ambit of the Second Amendment. And he found essentially that Bruin did not change the precedent in the 11th Circuit at all, that a felon could be prohibited from possessing a firearm, and that was consistent with our nation's history and tradition because these people are, in the judge's eyes, dangerous and therefore prohibited. And based on that, the magistrate judge decided to recommend denying the motion to dismiss that Mr. Pierre had brought. Now, on review, the district court decided to deny that magistrate recommendation, and then just kind of adopted its own decision, finding that the prior precedent in the 11th Circuit was not void anymore because of Bruin, that Bruin did not change or override in the precedent, and the precedent in the 11th Circuit was still valid despite what Bruin said. Now, after that decision from the district court, Mr. Pierre decided to appeal up to the 11th Circuit. Mr. Pierre argued that his conviction as applied violated the Second Amendment, so he brought an as applied challenge to the 11th Circuit. But the 11th Circuit ultimately affirmed what the lower court said and found that these types of arguments were foreclosed because of their precedent here in the 11th Circuit. They argued that their prior precedent controlled and that Bruin did not change any of that at all. Now, in response to that, Mr. Pierre then filed a writ of cert to the Supreme Court, asking for a reversal of that 11th Circuit decision in light of Bruin. He also asked in the alternative that the Supreme Court should grant at least a GVR in his case, send it back down to the 11th Circuit in light of Rahimi for a new decision, and ultimately just a challenge to the fact that the precedent there in the 11th Circuit was not, void or was not changed at all because of Bruin and Rahimi. In his petition, he stated that if the court does not grant plenary review of this petition, in the alternative, this court should grant the petition, vacate the judgment below, and remand for consideration in light of Rahimi. The 11th Circuit's categorical bar on as-applied challenges to Section 922G1 on the basis that the mere status as a felon permits disarmament cannot square with this court's rejection of the government's contention that Rahimi may be disarmed simply because he is not responsible. For this reason, and for the reasons explained above, as well as in light of the court's granting, vacating, and remanding of petitions raising a similar issue, this court should, in the alternative, grant, vacate, and remand here as well. Well, the Supreme Court decided, in fact, to grant, vacate, and remand this case back down to the 11th Circuit for a new decision and new consideration in light of Rahimi. That means that the 11th Circuit's precedent on felons in possession are now at risk, and they're going to have to review this as-applied challenge in light of Rahimi. This also sets up another critical review of whether or not someone can actually be barred forever from possessing firearms simply because they have a prior felony conviction. It also opens the door for an individual to bring these as-applied challenges, which were kind of blocked in the 11th Circuit because they were arguing that the 11th Circuit's precedent barred these types of lawsuits and these types of challenges. But here, because of this GVR, you have the Supreme Court saying, no, you have to look at this. So this is another important Supreme Court decision, a new order kind of setting things towards the right direction, where you have these challenges of individuals who are felons in potential possession of firearms, challenging these laws, challenging them under Bruin and Rahimi. And now you have the Supreme Court sending another case back down to the circuit court saying, yes, you have to look at this because it could potentially violate the Second Amendment. And you have to look at the text, history, and tradition of the Second Amendment to see if there is any history or tradition to support these restrictions. Now this case will be back in the hands of the 11th Circuit, and we will see ultimately how they decide to rule in this case. And if we get any more information, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help you fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.